Good evening, everybody. Good evening. It's so good to see you all, especially on this wet night. I wanted to give you all a warm welcome to St. John's College and a big thank you to all of our friends and colleagues associated with the University of Maryland Carey School of Law for visiting us here tonight. And a big thank you to Professor Monopoli for giving us the occasion to celebrate this wonderful relationship between St. John's College and the Carey School of Law. I'm going to turn over the podium now to our Associate Dean, Brendan Boyle. Mr. Boyle will take us to the next step in our evening. Thank you.
Thank you very much, President Pullman. Good evening, everyone. I, like President Pullman, am delighted to welcome you to the Great Hall in McDowell Hall in the grounds of St. John's College, Annapolis. I'm especially happy to welcome our friends and guests from Carey Law School at the University of Maryland, and I thank them for all their hard work in setting up this event. Shara, Allie, Justinia from the Advancement Office at Carey, Dean Laurent, and especially tonight's distinguished lecturer, Professor Paula Monopoli. This evening's lecture grows out of a partnership begun many years ago by the late Alan Hornstein, who served on the faculty of Carey Law from 1974 until 2004, and during that time earned a Master of Arts in the Liberal Arts here at the Graduate Institute of St. John's College. And distinguished though his legal scholarship is, it is especially moving to me to see how deeply informed it is by the transformative encounter he had with the texts, the great books, that constitute the program of study at the Graduate Institute of St. John's College. Those of you who have attended this lecture in the past, when we were honored to learn from Carey faculty members Peter Danshin 2 years ago and Max Stearns last year, know that in this introduction I have borrowed liberally, some might say too liberally, from a tribute to Alan Hornstein from his colleague, David Bogan. It's a tribute written to Professor Hornstein upon his retirement. That poetic tribute is titled A Raven and recounts what it was like to encounter Professor Hornstein in all his voracious gregariousness. Unlike Poe's Raven, whose refrain you all know to be nevermore, Professor Hornstein's refrain, said to colleagues and students at Carey and St. John's alike, was always, apparently, say more. I especially like this particular stanza from the tribute, a stanza which I have not quoted before. Here it is from David Bogan. Much I've marveled at his, Alan's, at his power to make any student flower, though their answer little meaning, little relevancy bore. For we cannot help agreeing that no other human being has been so blessed with seeing light that others all ignore. But Alan sees it, wrenching insight from the answer's core, with 2 words, simply just say more. I'd like to think that that refrain characterizes the faculty at St. John's too, at its best, that we, as tutors at St. John's, are, like Alan Hornstein, helping make students flower by simply asking them to say more, guided by the belief that wisdom is somehow already inside them, ready to be shared, only in need of the proper drawing out. A drawing out that most often simply takes the form of asking students to speak and being patient enough as a professor or tutor to listen as they, the students, say more. I will say no more about Professor Hornstein, however, in order to happily say more about tonight's distinguished lecturer, Professor Paula Monopoli, distinguished university professor and Saul and Carolyn Hubert Professor of Law at the University of Maryland, Francis King Carey School of Law, where she is also the founder of its Women, Leadership, and Equality program. She's the author of the monographs Constitutional Orphan, Gender Equality and the 19th Amendment, American Probate, Law and Leadership, and Contemporary Trusts and Estates. And though I cannot profess to know Professor Monopoli well, I can see that her own scholarship and teaching is marked by the adage, say more. From the moment she was asked to deliver this lecture to the very moment before the start of tonight's lovely reception, a reception whose loveliness, again, I thank Shara, Allie, and their team for putting on, she, Professor Monopoli, was inviting me and other members of the staff of St. John's College to say more. And those invitations to say more yielded lovely family connections and stories of Professor Monopoli's father's time in Annapolis at the United States Naval Academy, where he graduated in the class of 1952, to her own childhood visits to the Mid-Atlantic to support her father's work on the fledgling space program, to our own shared roots in a particular southwest corner of Ireland. All of this and much more about Antigone, originalism, and the development of legal education in America, this all emerged from invitations to one another to say more. I ask your forgiveness for not saying more about Professor Monopoli's many academic and professional achievements, which are too numerous to list. But I draw our attention on this occasion to the happy way that this event draws together communities and speakers committed to speech, community, and learning through speech. Somehow we keep finding ways in which our communities are joined by this commitment to saying more. Professors Danchin and Stearns did so over the past 2 years, and now Professor Monopoli this year, all of them committed to sharing wisdom through frank, open, and collegial exchange, to saying more, that is, to hearing more, all in the service of learning more. With that said, I'm delighted to welcome to the podium Professor Paula Monopoli to say more about gendering the Republic. Professor Paula Monopoli.
I'd like to thank Brendan for that lovely introduction, and it is just a delight to be here with you this evening. As Brendan noted, I've been to Annapolis many times, and my father took us to reunions at the Naval Academy. He took us to conferences. Whenever he had a chance to come back to the Academy, he would come back. And he was a first-generation American. His parents were Italian immigrants, and he was the first Italian-American nominated to the Naval Academy from his home state of Rhode Island. And so his parents were very, very proud of that, and they spent a lot of time coming to visit him when he was here as well. It was my dad who first pointed out St. John's to me. So in those visits, we would drive by St. John's, and he told me about the unique curriculum, about the great books. And so it's just a delight to actually be here on the campus finally after those many, many years. He was a professor of engineering eventually at the University of Massachusetts, and he didn't know much about law. So when I came home in high school and I said I wanted to become a lawyer, he said to me, "You should read Blackstone's commentaries in the original." And I think it made an impression, right? He thought that this was a very good idea for a curriculum, the great books. And so he had a profound belief in the mission of the university as an institution, in generating and disseminating knowledge. And I think that tradition has been something that I've held on to. My mother, Eileen, was the daughter of Irish immigrants, and she graduated with a master's degree from Brown University in history. In 1958, which was the year that she was very visibly expecting me. And that status, condition, drew the ire of one of her male professors at Brown, and who then told her that she was taking up the space of a man and she would never use this degree. And I think I heard that professor because my scholarship, my work has always been decidedly feminist, and so I attribute it to that experience. So I'd like to share some of my work with you tonight, things that I've been working on, and I want to discuss a radical idea that emerged in the years following the Civil War. And that radical idea was that women not only had the capacity to reason and for intellectual development, but they also had a natural and a constitutional right to self-govern, to the vote, to the ballot, right, suffrage. And they should be deemed to be, right, as equally capable of that in our constitutional republic as their male counterparts. And again, I'm going to situate this radical idea within the context of a brief but spectacular period following the Civil War called the New Departure. And that period ran from about 1868, 1869, depending on who you read, to about 1875, when it came to what appeared to be an end, but I'm going to argue that it wasn't the end. So my goal is to persuade you tonight that these women had an impact in terms of going to Congress, going to the courts, right, trying to persuade everyone that this radical idea should be embraced, right? And my claim is that they gendered the republic, thus the title of the lecture, right? And by that, I mean that they changed perceptions. Now, not right away, and a lot of this takes a long time to happen, right? But they laid the foundation for a different kind of understanding by subsequent generations about the relationship between women and the state and citizenship. And so the central tenet of that kind of idea, right, of a republican form of government was that the consent of the governed was essential, right? That self-governance by the people was the heart of that idea of political organization. And the New Departure generation used that idea to make these arguments. So they didn't achieve their goal right away. In 1875, things kind of came to a little bit of an end. But again, it kind of echoed down the generations, this idea that the Constitution could be interpreted in a way, right, that conferred the key to self-governance, the ballot, suffrage, the vote, however you want to think of it, on women. And it made an impact. Now, when I explained my work to Alan Hornstein many years ago, that I wanted to restore the memory, the constitutional memory of women in the Republic, of women who went to Congress, went to the courts, engaged in civil disobedience. I'll talk a little bit about that tonight. When I told Alan that I wanted to restore that memory, because I think it's very important, right, for later generations to remember, because often I think the public perception is that women weren't there. They were not in Congress at the time. They were not, right, in the courts, and they were. When I told Alan about that, he said to me, have you ever thought about reading Antigone with your students in your seminar? And I had not. But I've done it ever since, and I think that his suggestion came from his time here at St. John's, and it was a wonderful suggestion. It's a remarkable play. So I want to begin with a few thoughts about Sophocles' play, written way back in 440 BC, and how I sort of frame it and how my students and I read it together to talk about the gender schemas around the relationship between women and the state itself. So many of my students have read the play in high school or in college, but a lot of them have said to me that this particular theme, right, was never teased out, or they were never kind of aware of it when they first read the play. And so reading it has proved to me that it's an incredibly useful frame for talking about these issues the rest of the semester, right? The issue of linking these ancient gender schemas to our own unique American experience in this realm, and how difficult and entrenched these schemas are, right, about sort of subordinate citizenship, if you will. So talking about the play lets me think about and surfaces for my students that one of the reasons that it's been so difficult for women's activists over the years, and again, we're sort of focused on the mid-19th century here, but obviously this has been a very long movement, and one of the reasons that it's so difficult to change things, and that it will be so difficult for my students, many of whom I see here tonight, which is wonderful, my former students, is that these gender schemas are so entrenched, right? So my students have become lawyers and judges, and they're in Congress, some of them, and they have now the power to make some of these changes. But what I want them to understand is how entrenched those schemas are and why it's difficult for them to make this change. And Antigone helps me frame that issue. And this has taken on a particular salience, right, for me in the last few months, as I've heard calls to repeal the 19th Amendment that I never thought I would, the right for women to vote, right? So it's really important to keep this discussion going with my students, and Antigone really helps tremendously. So this is a part of what I want to talk about in Antigone. But for those of you who haven't read it in a while, or maybe didn't read it previously, right, so it's, we're going all the way back to maybe 440 BC, right? And so Antigone in the play has defied her uncle Creon, who's the king of Thebes, and she's buried her brother. Creon had ordered her brother's body not to be buried, to remain unburied, because her brother had launched an attack on Thebes and on Creon. He was contravening, right, the king. So Antigone believes it's her duty to bury her brother, and she believes that that duty comes from a higher law, right? She talks about the law of heaven. And people in the 19th century might have thought, natural law, right? Very kind of similar concept there. So Antigone faces a death sentence as her punishment for disobedience to the king. And when I read the play with my students, I ask them to consider how it illustrates the uniquely subordinate relationship between women in the state. And for example, Creon at one point in the play says if Antigone goes unpunished for her disobedience, he says, truly, if she wield power uncensured, if I don't respond to her, she is man and I woman, right? So there's this kind of implicit terror, and one might argue fear of emasculation, right? And this is part of the theme, right, of particular kinds of features. It's one feature of the relationship that I want to focus on tonight, that reading Antigone is seriously effective in helping me communicate to my students, and that is that challenging the state is an even greater affront, right, and more destabilizing to the state when women resist than when men do. This theme, which is the sort of the unnaturalness of a woman disobeying the state and the heightened risk to the state, right, that her disobedience might cause, sounded in the American women's rights movement in the 19th century that I'm going to talk about. Right? This was a fear. Anti-suffragists argued that if our republic were to allow women to self-governance, again, coming from that Republican idea, using the ballot, it would be against the natural order of things, and social disorder would result, anarchy would result. That was part of the pushback, right? So very similar down the ages. So in the play, Creon crystallizes this same theme, right? When he says that lives no greater fiend than anarchy. It's anarchy, social disorder that will happen if I allow, right, her to engage in disobedience here against the state. She ruins states, turns houses out of doors, meaning anarchy, right? Therefore, we must assist the cause of order, right? It's about order. This forbids concession to a feminine will. And better be outcast if we must of men than have it said a woman worsted us. right? So, again, I will make the claim that this fear of anarchy, right, this push for changing the social order is deeply connected here. And again, connected to this, of course, the Greeks had the belief, went down the ages, that women lacked the capacity to reason. They were governed by emotion, right? And as such, they were incapable of self-governance in a republic. One needed reason to make these decisions about governing. And it was another rationale, obviously, for subordinating them to men. And Diana Kuhl describes the ancient Greek association of women with nature and dark powers inimical to the mind, right? This deep, sort of dark, right, emotional being rather than an intellectual person who could reason. And now she observes that this inability to exercise this type of reason required for political participation, right, resulted in women's exclusion from the citizenship in the city-state, right? And it's a very similar theme we see in the mid-19th century. So the idea that if women were allowed to self-govern, anarchy would result, traveled down the ages without much resistance, but American women in the remarkable period that I mentioned, the New Departure, pushed back very publicly on this idea with a counter-idea. They resisted. That counter-idea, as I mentioned, was the radical proposition that women not only had the capacity to reason, but they had a natural and a constitutional right to self-govern on an equal basis with men in our constitutional republic. And that's the radical idea I want to unpack with you this evening. So there's a tremendously enlightening history of women's early education in the early republic, the early movement to educate women and girls by Mary Sarah Bilder, who's a wonderful legal scholar. Her book's called Female Genius, which is an interesting title. And she reminds us that there was this movement in the late 18th century to educate women and girls. So the movement was premised on the controversial idea that women and girls had the intellectual capacity that could be developed, right? And so thus they could be treated as men's equals. And again, that idea was radical. And she reminds us that in the late 18th century, genius just meant intellectual capacity. It doesn't quite have the connotation that we give it today, but it means that, you know, in the classic text they were reading, genius or intellectual capacity was always coded male. It was always associated with men at the time. And so to insist that women could be educated, to insist on female genius, she argues, was radical. And she connects this movement to educate women and girls, right, with the sort of larger project of Enlightenment liberal progress, right? It was consistent with that project. Now, like the Greeks, on the whole, Enlightenment thinkers tended to, you know, eschew the idea that women had the same capacity to reason as men. We didn't see that getting much traction, but they generally embraced a separate sexual spheres view of where women should be in the sort of liberal society, right? With women staying in their lane. Their lane was the domestic sphere, while men occupied the public sphere of governance, and they virtually represented women as a matter of self-governance, right? The idea that women were incapable of operating in the public sphere through their writing and their thinking is what 18th century writers like Mary Wollstonecraft and Catherine Macaulay, historian, resisted in their writing. They rejected the idea that women could not be educated in a way that allowed them sufficient capacity to contribute to the world of arts and letters, governance, a world beyond the domestic sphere. So Wollstonecraft, in A Vindication of the Rights of Women, writes that the intellect would always govern. She actually was what I would call an assimilationist. She encouraged women to adopt these features of men, to persuade them to acquire strength, both of mind and body, that they sort of moved in that direction, which might be somewhat controversial among feminist scholars today. But those ideas traveled from England over, right, to the United States. And it saw this movement to educate girls as early as 1789. In Boston public schools, girls were being allowed in. And then there were, of course, private academies for girls, and we see seminaries like Mount Holyoke popping up before the Civil War, and colleges like Smith and Vassar following on, which were actually a rejoinder to the idea that women, right, didn't have the capacity for rigorous intellectual development. So this idea that women had sufficient capacity to govern was connected to the fact that the United States had embraced a Republican form of government, as I mentioned, in its original Constitution. And a Republican form of government meant the people were sovereign, and the political organization was premised on the consent of the governed. So the idea of self-governance was itself then operationalized via the ballot, right? Via the right of suffrage. So this quote that I've got up here for you, the right of suffrage in a republic means self-government. The ballot is the scepter of power in the hand of every citizen, right? And this idea was that this is certainly true for men, right? We think it should be true for women as well. This is Elizabeth Cady Stanton writing. That's where the quote's from. So let me talk a little bit about Elizabeth Cady Stanton. Very interesting and important American figure, right? Somewhat forgotten. She's the very embodiment of American resistance to the idea that women lacked reason and were incapable of intellectual development. She was born in 1815, and she was allowed by her father to read law books, to study in his law library, which is a privilege, right, of being upper class. And she had access to legal treatises and to cases. So she wasn't a lawyer, but she was trained to think like a lawyer. She trained herself in many cases. He used to talk about his cases with her. Stanton becomes the intellectual engine that underpins the women's rights movement in the 19th century. Especially that period that I mentioned, the new departure following the Civil War. Now, you may be familiar with older portraits of Stanton, but I use this one on purpose with my students, who will recognize it, I think, some of you, right, to illustrate how young these women were when they made these major radical arguments, right? And they went out and contravened norms. So, the purpose of the meeting that you're probably all familiar with, which was Seneca Falls in 1848. Elizabeth Cady Stanton is one of the architects of that meeting. She was only 33. My oldest children are 33. I have triplets, by the way. So 3 33-year-olds and a younger son who's 30. That's remarkable to me when I think about this, right? She's convening, this is the first, there was a movement before that, and there's really wonderful historians have documented part of that movement before. But this is the first official kind of convening, if you will, right? She's 33 years old. She had 7 children eventually and did all of this while raising 7 children, which is, again, a remarkable thing, right? But how young these women were, and this is an inspiration to my students, my law students, when they were gendering the Republic with their radical ideas, right? So the purpose of that meeting was to debate radical ideas about removing the disabilities that were in law that applied to women. We call this the legal regime of coverture, and some of you may be familiar with coverture. But it was the idea, right, that there was this sort of series, and we had inherited that, right, from British common law. We brought it to this country, we kept it up. It's the whole sort of network, if you will, of state laws that kept women financially subordinated. So one had to turn over any income you made, any property you made to your husband when you got married, right? And this idea that the sort of entity of the marriage was one person, and that one person was the husband. But it was far broader in terms of its right to control their wives' lives, property, liberty, physical body, if you will, right? It was incredibly subordinating, and so this purpose of Seneca Falls is to attack the broad kind of regime of coverture. And in doing that, Stanton vehemently argues, right, against these ideas. She writes, she petitions Congress, she gives lectures, a lot of them gave lectures, to sort of either spread the ideas or in some cases to survive, right, as a matter of income. So she's a remarkable person, a remarkable American, whether she's, male or female. And I point out to my students, right, this is a person who thought and wrote about big ideas, about political theory for years and years. She was an intellectual giant, but she was deeply flawed, and I'll talk a little bit more about the ways in which her use of racist and nativist tropes, right, diminished a lot of perhaps, right, her stature, her effectiveness, and we have to acknowledge and face that when we're sort of restoring this history. We have to look at all of it, right? Yet, like a lot of women who played a significant role in the development of the American story, she has been essentially forgotten as in terms of her role. So in 1848, they're at Seneca Falls, and the product of that meeting was the Declaration of Sentiments. Now, the Declaration of Sentiments is essentially a riff on the Declaration of Independence, right? So you'll notice that part of the final product of this meeting is, you know, this recitation, which sounds a lot like the Declaration of Independence. The history of mankind is a history of repeated injuries and usurpations on the part of man toward woman, having in direct object the establishment of an absolute tyranny over her. To prove this, let facts be submitted to a candid world. Does that sound familiar, right? So the sort of the tenor of this is to turn, right, this on its head and say, well, you know, half of us have been excluded from this polity. So they're asking, there's a long series of demands, and the list includes two things which I want to point out to you, right? The first is what you probably already have thought of. It says, man has never permitted her to exercise her inalienable right to vote, right? Inalienable right to the elective franchise. That's sort of now in 2025, we say, oh, it was about the vote. It was only partly about the vote, and in fact, the vote was pretty controversial. There was not consensus among the women who met about whether or not they should even ask for this. It was deemed too radical by a lot of them, and eventually it squeaks through and it gets in the final document. But the other demand, of course, is, right, he has denied her the facilities for obtaining a thorough education. All colleges being closed against her. They link those two ideas, right? Education and self-governance, the right to the ballot, right? And again, this sort of point is, this is a subordinating kind of effort to keep us from self-governing, right? When we have the capacity, you close the doors of education to us. Education was critical. It was part and parcel of the demand for suffrage, right? It was a broader demand. So they saw these two ideas as inextricably intertwined in the Declaration of Sentiments. Now, this idea that women were, right, didn't have the vote, it goes back to the sort of status quo before the Civil War. We're talking 1848 here. At this time, right, virtually none of the states allowed women to vote. There was a brief but spectacular period in New Jersey from the founding to about 1807 where women actually voted. Nobody sort of, right? Then they stopped it in 1807. But generally, right, women were not allowed to vote. And the sort of idea was that states were the correct repository of deciding who was eligible to vote. That was within the purview of the states. There was no sense that it had anything to do with the national government at all, right? So states could deny women the vote as a class, based simply on their sex, right? So that was sort of the status quo. And the premise of that denial was that the fundamental unit of government was the family. That was the first level of government, and that the father or the husband would consult with the household, or not, and represent those people well who were in the family household, right? And they could virtually represent them. So that's an important idea to remember. The other idea to remember is the idea that rights as citizens were separated. So there was this idea that one could have civil rights but not political rights and still be a citizen, right? Which was the condition that white women were in, I should say, before the Civil War. Black women, right, were not citizens. So that idea was important for Stanton to push back against, right? And the other people that I'm going to tell you about. So this idea of coverture, right, if they were married, was an important one to sort of dismantle because it shored up all of these ideas. And women were relegated to that private sphere, that this was the idea that this concept of separate spheres, right, was the sort of norm before the war. Then the women's rights movement, right, begins at Seneca Falls, leading up to the Civil War, is a broad movement, right? They're pushing against coverture, and many of the women at Seneca Falls were involved then in the lead up, were involved in the abolition movement. Stanton was involved in the abolition movement as well. And they advocated tirelessly for abolition. And there they learned, I would suggest to you, those, right, how do you petition Congress? How do you give a speech, right? They learned an enormous number of political skills, and they used these sort of constitutional ways of presenting grievances later on to great effect. But they're all involved in the abolition movement. They're tirelessly advocating for the repeal of the legal regime of chattel slavery, right? Very much involved, and a lot of their husbands were involved as well. They also eventually start arguing for universal suffrage, which is every adult in the United States, black, white, male, female, should have the vote, right? This is a universal suffrage, so they were all sort of on board with this. Yet after the war ends, those white male abolitionists, right, that they had helped and who held elective office in Congress, turn away from these women, who had been their allies in abolition. And they drafted and enacted, right, the 14th Amendment, a new amendment to the Constitution, which not only failed to include women explicitly, but it implicitly excluded them from the vote. Now, how did it do this? So if you want to sort of take a look here at this, in Section 1 of the 14th, we get the important provision that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens, right? This is a very important provision. We're talking about it as we speak, right, in this country, in Section 1, right? There's also in Section 1 the Privileges or Immunities Clause. That's going to become important to their argument. And that is that no state shall make or enforce a law which shall abridge the privileges or immunities of citizens of the United States, national citizenship, this concept of national citizenship, right? But it's Section 2 that got them very worried, right? And this was a bitter pill for both black suffragists and white suffragists. In Section 2, which is a penalty clause for the states, presumably the Confederate states might deny black men the vote, right? They will have their representation in Congress reduced. For the first time, the word male is inserted in the Constitution as a limiting factor. It implies that it's perfectly fine for states to exclude women. They won't be penalized, right? They say, but when the right to vote is denied to any of the male inhabitants of any state, right, then they'll be reduced in proportion to the number of such male citizens. This was a huge problem for the women's movement. They split over this issue. They split over the issue of the 15th Amendment because women are not included in that. There's two branches of the women's suffrage movement. Lucy Stone and Frances Ellen Watkins Harper formed the American Women's Suffrage Association. Stanton and Susan B. Anthony, who you've heard of, I'm sure, form a different group, the National, right? They don't want to support any of this, basically, but especially the 15th, because it didn't include women. Lucy Stone and Frances Ellen Watkins Harper were saying, look, you know, we fought for this. We're going to kind of agree to this, and then we'll keep working toward women's suffrage. So this was a basic philosophical decision that each suffragist had to make. But the original Constitution was textually neutral, right? 1787, there's no limiting factor. There's no references to male voters or male citizens in that Constitution. And so that was the huge problem for Stanton in terms of thinking about what was happening with the 14th in particular. This was a sea change. Stanton immediately understands its significance, and she says, in terms of implications for women having the right to vote, she says the amendment, right, if that word male be inserted as they're debating the 14th, they're in there, they're in Congress, they're trying to get it out, they're trying to sort of argue it shouldn't be in there. She says if that word male is inserted, it'll take us a century at least to get it out. And it almost did, right, if you count the time to the 19th Amendment in 1920. It took about 50 years. So she was correct that it was going to be a barrier. Now, the 14th Amendment is a wonderful amendment. We use it all the time, and but I'm just sort of explaining what the debate was. But the important point here is that women were there. They were making these arguments. They were making these arguments in Congress. They were making these arguments in court, which were radical arguments. This is Virginia Minor. Virginia Minor, right, comes in. Like after the 14th, everything is bleak in the women's rights movement. Everybody is sort of concerned. Nothing's going to happen. Virginia Minor is a women's rights advocate from St. Louis. She's married to a lawyer. She's married to Frances Minor. Frances Minor is a UVA law grad, like me. And they start thinking about how are we going to push back, right? Like we do today. What are the constitutional paths left to us sometimes when we get cases decided by the court? So their sort of thinking, right, is to come up with a theory, an alternative interpretation of the 14th Amendment. Stanton's thinking the same thing in some ways, but she's also thinking about additional arguments to make. And together, they come up with a legal and a political theory, if you will, right, to try to push back on this, to try to get the courts, to get Congress to declare that women do have the vote under the 14th Amendment, despite the language, right, which is what they're asking for. And we'll come back to Virginia Minor in a second. So what comes out of all of this is this argument, right? These are the ideas that were underpinning this new departure period that they come up with. So again, the prevailing view is that states, right, prior to the 14th are the proper entities to decide who gets to vote, to decide eligibility. That's obviously changed to some degree with the 15th, with the 14th and the 15th Amendment. It becomes a matter, the national government can stop states from disenfranchising people based on, right, race, color, previous condition of servitude. So that sort of leads them to think about the fact that there is, this is Stanton's argument. We're a republic. You say that this country is a republican, has a republican form of government. That requires the consent of the governed. And self-governance, she argues, is a natural right. It doesn't have anything to do with the Constitution. It predated the Constitution, right? It comes out of natural law. We have the right to defend ourselves. We don't give that up when we sign the Constitution and enter into that compact. We've always had the right of suffrage to self-govern, right? That's a natural right. A lot of people disagreed with her, but that was her argument. And it survived the Constitution. It was more significant. It could not be abrogated by the states because it was a natural right. That we came into the constitutional arrangement with rights that we didn't give up, and that was one of them. So that's her kind of argument, right? Minor adds a textualist kind of 14th Amendment argument to the mix, second pillar of the new departure argument. And that is that women are citizens under Section 1 now. For the clearly first time, we get a definition of citizenship. The ballot is the means by which citizens self-govern, right? And they're citizens. It says they're citizens. And thus, women have both a natural right, which is Stanton's argument, and a constitutional right, that's Minor's argument, the 14th Amendment argument, right, to vote. And they also argue, Minor does, that voting, and Stanton agrees, that voting is a privilege of national, not state citizenship. And so this clause, which, right, is in the 14th about protecting from state infringement, the sort of the rights of us as national citizens, right, and that voting is one of those, becomes a basic sort of building block of this argument. And they are making this argument again. In Congress, they're testifying. They're testifying, right? They're creating this argument and then disseminating it. This is another sort of really important person in this fight, if you will, who's Mary Ann Shadd Carey. I think probably, I'm guessing most of you have not heard of Mary Ann Shadd Carey. She is a remarkable part of this story. She goes and gives testimony to Congress as well. Now, Mary Ann Shadd Carey was born in Delaware, right? Her father is a free black man in Delaware when she's born, so she is not enslaved, but they have to leave Delaware for Marianne, Shad Carey, and her siblings to be educated. So they have to go to Pennsylvania to be educated, and they get educated in the sort of Quaker tradition. She has to flee the country with her siblings when the Fugitive Slave Act is enacted, so 1850, they go to Canada. She becomes the first black woman publisher of a newspaper in North America, the Provincial Freeman, right? She's just an incredibly brilliant person. She comes back after the Civil War, and she actually goes to Howard to law school. She's one of the first black female lawyers graduating from Howard. And she is in Congress. She is submitting testimony about how it is really important, right, for black women to have the vote as well as black men. In 1871, she tries to register to vote with a bunch of other women. In the New Departure, they were doing mass voting events. They were showing up at the registrars. They were getting arrested. Susan B. Anthony famously got arrested for illegal voting, gets tried in a sham trial, right? Never pays her fine. It's a fascinating story, but it's popular constitutionalism, right? They're out there sort of using civil disobedience as well. So Marianne Shad Carey tries to vote, they get turned away, and she's involved in a movement to try to get Congress to at least change the District of Columbia's law in voting, which barred women from voting and only, right, allowed men to vote. So she submits testimony to the House Judiciary Committee. We're thinking 1872. The fact that a woman was speaking in public was a hugely radical idea, right? These women were incredibly courageous. They were incredibly brave. And so she submits her testimony to the House Judiciary Committee. She makes the argument that black women, right, were entitled and had provided service to the nation during the Civil War, and that was a basis for them to be treated equally, right, with their male counterparts. And so the beginning of her testimony is around the consent of the governed. They hearken back to these Republican ideas, right, when they make these arguments. And so she talks about in her testimony, you know, she says, we're taxed, governed in other respects without their consent. They respectfully demand that they be invested with the right to vote as do men. And thus, as in all republics, right? There was this, right? They were familiar with the history. They were familiar of the prior republics. But just as in all republics, indeed, that they may be in future governed by their own consent. And again, I want you to just think about how remarkable that is, that there's a woman submitting testimony to Congress, and a black woman, right, who had made these arguments to Congress and is in the public sphere, right? It's just, it's an amazing thing. However, all good things must come to an end, right? We get the end of the New Departure in 1875. Right? And so, you know, I mentioned that activists were doing these mass voting events like Susan B. Anthony, and this is what Virginia Minor, who I introduced to you a little while ago, this is what Virginia Minor did. She went to the registrar in St. Louis, Reese Happersett, and she said, I want to register to vote. And he said, no, you can't vote. The Missouri Constitution says male citizens are the only people who can vote, right? So she's turned away at the voting booth. She brings an action in circuit court, she loses there. She brings an action in the Missouri Supreme Court, she loses there, and she gets the court to review the case, the Supreme Court of the United States. In her brief, she's arguing, right, that suffrage voting is a matter of national citizenship under that provision I pointed out to you, right, the Privileges and Immunities Clause, or Privileges or Immunities Clause of the 14th. And that they're entitled to citizenship, they are included in the definition in Section 1 as citizens, and that they should have not only civil rights, but political rights as well. Supreme Court decided against her, not surprising in 1875, but still, right, it concedes that women are citizens. Yes, you're citizens under Section 1, you're right. But that doesn't mean you have political rights. And it goes back and it looks at the 14th Amendment, these new provisions, and it says, right, it doesn't add to the privileges of national citizenship. There's nothing new here, right? That argument fails. The court uses what I would call a truncated kind of historical retrospective mode of interpretation to go back, and it looks to see whether states were allowing women to vote at all, right, at the founding. They sort of just benchmark it at the founding. And these women are saying, right, Minor in her briefs and right, the people who are making the argument for her are saying, look, you should take into account what's changed since the founding. Because of the work of the women's rights movement, women are now more, they had gotten some of those coverture laws repealed, they are more economically independent, they go to colleges now, they can reason, right? You should take account this change in social status, economic status, legal status. Court's like, no, we're going back to the founding. We're not looking in that any changes, right? Sound familiar? All right. And even if you go back to the founding, New Jersey let women vote until 1807, and right? So from the founding, there was one state which allowed it. Well, they just sort of, well, that's an exception, and ignore that, right? And they argue, there's a structural argument too. We wouldn't have had a 15th Amendment if the 14th Amendment had included voting rights. So your interpretation is not gonna fly here, right? So they reject the idea that the right to confer suffrage, determine who's eligible, sits anywhere other than the states, right? That the 14th didn't change that. It claimed to be divining the original sort of intent through this retrospectively historical view of what was going on at the time. What they did is they refused to consider what they called outside proof, right? And that's this quote that I took to show you. They reject this idea that there should be any consideration of women's need for the vote, right? Of how it would make them. All of the arguments that these women were making in Congress, that it will make us self-sufficient, right? That it's one, it's a moral matter, but two, as a functional matter, we can, better take care of ourselves if we can self-govern. And the court says, right, no argument as to women's need of suffrage can be considered. We can only act upon her rights as they exist, right? It's not for us to look at the hardship of withholding. That's not our job. Our duty's at an end if we find it's within the power of a state to withhold, period. So with this kind of unanimous rejection of the theory, right, that a women's right to vote was an attribute of national citizenship, the minor court effectively ended the new departure. In the wake of this decision, right, the National Women's Suffrage Association turns back to, Katie Stanton had looked at this previously, getting a federal amendment based on sex that would prohibit the states, right? Actually, that it changed over the years. But essentially what came out in 1920 was the 19th Amendment. And so she turned her sights on that. Other suffragists turned their sights on a state-by-state campaign, which is a long story. However, right, so no argument. They would not look at the facts on the ground. They would not look at women's lived experiences. They were saying no, right? This is not a mode of interpretive reasoning that we recognize. And so, so while these women's rights activists did not prevail in persuading the court or Congress, right, to hold that voting was a matter of national citizenship. My claim is that they did lay a foundation, right? For both the ratification of a federal suffrage amendment 50 years later, they introduced these ideas into the national discourse, into the collective consciousness of Americans, that women were capable of self-governing, that they were capable of reason sufficient to do that, and that perhaps they might even have a constitutional right? So they introduce these ideas. These ideas take time to get traction in the collective consciousness of a society, right? And with their presence in Congress, just their mere presence in Congress, giving testimony. There's a picture in the back of Elizabeth Cady Stanton, a sketch of her giving testimony. It's a remarkable thing. There's also some pictures of the women who were picketing the White House for the 19th Amendment, which might be interesting to you guys to look at. So, I would say to you, they didn't achieve their immediate goal, but they did sort of bring this radical idea more to the fore, right? That women could self-govern, and they had a natural and constitutional right to do that. So, ratified in 1920, the 19th Amendment has been described by some scholars as the largest or the biggest single democratizing event in American history. That in one day, theoretically, 26 million women were enfranchised at double the size of the electorate in one fell swoop. That's a pretty huge achievement, all right? And the foundations for that came during the New Departure with the introduction of these radical, at that point, ideas. So their efforts to gender the republic, right, I would argue to you, were successful. They just took a very long time to get traction, as many ideas in a liberal society do, right, when we hear new ideas. So they gendered the republic in another important way as well, and that was by proposing this alternative interpretation or interpretive theory of how the court should reason around making decisions. Some scholars have said that that is akin to what we would consider today to be a living constitutionalism, right? Where the court considers outside factors. And that, you know, there was some benefit to having this alternative. Again, the court didn't buy it, and we don't see it, but we do start to see it with the legal progressives, right at the turn of the century. We begin to see this kind of a willingness to look to data, to empirical evidence, the Brandeis Brief, for those of you who are lawyers, right, in the audience. We see this transformation, and for much of the 20th century, living constitutionalism is the kind of the dominant mode of interpretive reasoning. Now, recently, we've gone back to originalism, and originalism plus history and tradition, depending on what you're arguing. But that idea that they again laid the foundation for an alternative reasoning, interpretation, or interpretive theory, I think is one which is also really important to think about. And you know, I'd suggest that this kind of interpretive reasoning is not only living constitutionalism. They centered women in this theory that they presented to the court. They centered women's lived experiences and need for suffrage, need for rights. And that is akin to a feminist constitutionalism or a gender constitutionalism, which a lot of legal scholars today are writing about, right? So they were the sort of antecedents of what much of feminist scholarship today and people pushing back on some of the recent decisions by the court who are arguing for a different theory. So I think that, you know, again, they were powerful. They were not persuasive in their time, but these ideas got into the collective consciousness. So gendering the republic was hard work, and it was very, very difficult. It was expensive and exhausting, right? And the work on suffrage itself took 72 years to be embedded in the Constitution with the ratification of the 19th Amendment, and almost 50 years after that, 1965, till we get the Voting Rights Act so that women of color can actually vote, right? So it's a very long battle. We still don't have an Equal Rights Amendment in our US federal Constitution. A lot of states have them, but we don't have one. That's another lecture for another day, right? That was put into the hopper in 1923. Came out in 1972, failed to be ratified by sufficient number of states 10 years later, right? We've got the whole story, which many of you are familiar with, about recent ratifications. But while these women didn't prevail in the New Departure period after the Civil War, right, they were remarkable women making radical arguments in the public sphere. And we eventually saw courts adopt some of those arguments and some of those ideas, right? So as scholars, we might ask ourselves, like, what is it about the United States that makes it so resistant to elevating women, right, into full citizenship? That is sort of still this kind of subordinate citizenship, and the relationship of women in the state seems fraught. But when we look back in Antigone, it's not just us, right? If you contextualize this, we see that women have long been, for centuries, thousands of years, subordinate citizens, if they're ever citizens at all, right? And so the US is not necessarily an outlier in this regard. Gender schemas about women's proper relationship to the state have existed for thousands of years across cultures. But as a matter of politics, we might ask whether or not we're a better or worse constitutional republic for that resistance to connecting women's relationship to the state in a direct way, right? Not being derivative, not being contingent or subordinate, right, with virtual representation of women's interests by men. And I'd suggest that we're not. But whatever your answer, it's clear that it's a different republic, right, than it would have been without these women activists. And lawyers like Stanton, Minor, Shad Carey, right, advocating for alternative interpretations of our Constitution, radical interpretations that actually took into account women's lived experiences and subordinate status in our republic. So by introducing these radical ideas, these women did influence how we think today about what the Constitution should mean as a normative matter. And we as legal scholars are still building right on their arguments. We're still highlighting the illegitimacy of modes of constitutional interpretation, like originalism, that benchmark definitions of liberty against laws enacted when women could neither vote nor hold public office. Right? And so I'll leave you with the words of Elizabeth Cady Stanton, which ring as true today as they did in the 19th century when she dared enter the halls of Congress and dared to discuss constitutional law and alternative interpretations of the Constitution, right? And I've got it up here for you. She said, "Though the world has been steadily advancing in political science and step by step in recognizing the rights of new classes, yet we stand today talking of precedents, authorities, laws, and constitutions, as if each generation were not better able to judge of its wants than the one that preceded it. And if we are to be governed in all things by men of the 18th century, and the 20th by the 19th, and so on, the world will always be governed by dead men." Thank you. You want me to turn that off, Susan?
Thank you all, and we will take a